Hey guys, today we are going to talk about ADR. What is ADR? It is Alternative Dispute Resolution. Specifically, we want to talk about it in California, but just giving you guys some legal background. Federal courts, especially those in California, are going to force you to ADR. So ADR is like, hey, you guys are suing each other, but would it be cooler and save a lot of money if you just talked it out? There are different types now. I can actually experience I will share my personal experience with ADR, which was relatively recently. So this is 22. Order referral to ADR, number one, judge. So there are many different ADR. It could be a lawyer. It could be a retired judge. So the person running our ADR was a retired judge. The current judge in this case, he actually was that was his court. And then when he retired, the judge for our case was our current judge. So everything is very interconnected. Don't think it is not. So my lawyer actually had a really good relationship with the ADR retired judge. He knew himself well. He actually had also known the current judge that was residing our case, really friendly with everybody, which would later be key to resolving the issue. The court, having reviewed the parties' request, ADR procedure selection from ADR 01, the notice of parties of court directed ADR program, or the report submitted by parties pursuant to Federal Rules of Civil Procedure 26S or F, hereby orders this case referred to ADR Procedure 1. So there are 3 different procedures in California. This case is referred to the magistrate judge assigned to the case or the magistrate judge in Santa Barbara. Let's skip that because that's not what they clicked on. Counsel are directed to contact the magistrate judge's courtroom deputy to arrange a date and time for the ADR proceeding. So even if you do not want to settle, even if you have zero inkling of wanting to settle, and the other person also doesn't want to settle with you, you still have to do this. On the off chance that you do reach a settlement, even if it is a very, very low probability, it saves everyone a lot of time and a lot of money. So and this is, again, if you ever get sued, you will be part of this process, whether you like it or not. So there are a few things that happen before the ADR session. Confidential briefs or statements. Each side submits a confidential mediation statement to the mediator or magistrate judge. Here we have a magistrate judge. This includes a summary of the dispute, key facts, legal issues, damage calculations, prior settlement discussions. These are not filed with the court, and so they remain private. So none of these documents in ADR ever become public. So we are talking about these public documents on Court Listener. Anything in ADR does not get published to Court Listener or elsewhere. It is a private negotiation, if you will. Exchange of key evidence. Often both sides exchange relevant documents so that everyone understands the strength and weaknesses of the case. It's almost like a mini trial. It is exactly like a mini trial now that I think about what we're trying to accomplish. For example, proof of copyright registration, alleged infringement files, or revenue data. Decision makers must attend. So I actually didn't want to attend because it was really far away from my home, but my lawyer made me attend, and I'm glad that we did that. Federal court requires that someone with full settlement authority be present. So this isn't a joke. You're not going to send like your intern who has no decision making. Federal court requires somebody who can say yes that day. If the offer is appealing, they can say yes, and then it is over. If you're a company, this means a top executive must attend, not just an attorney. Again, this is what my attorney told me. I was unaware of this, is that I couldn't just send him. I had to go myself. If you are individual, you must attend personally. So in this case, we will have Denims attend. Now, they're not going to sit in one room together. They're going to sit in 2 different rooms, and the ADR individual, in my case, a retired judge, but in this case, the magistrate judge, is going to go to Ethan and say, Ethan, what do you want? What damage do you think that will get you to settle today? Ethan, what do you want an apology? And Ethan would tell the judge, okay, this is what I feel I deserve. This is what I would settle for. And typically they're very smart. They ask for a range of damages or a range of apologies and so on. This is like the least I would take, and this is what I'm actually hoping for. And only the judge really knows what the range is from the plaintiff and defendant. And then if there's overlap, there you go. There is a settlement. So there may be overlap where both parties just, this is my range, that is your range, and somewhere our ranges connect. Or if there is no overlap, they might just take the high and the low and then average it out and then average it again to see if that would be something palpable for both parties. ADR is a very interesting mechanic. And like I said, in California, we'll get to this later, in federal court, you have to do ADR. So the ADR, what is the ADR actually composed of? The process depends on whether it's mediation or settlement conference, but basically it's the same thing. It's a joint opening session. Everyone meets in one room or a virtual room. The mediator or judge explains the rules. Everything is confidential and off the record. Nothing said during ADR can be used later in court. And it's really important to understand that. There is no like admission of guilt. There's no, oh man, the whole idea is none of this will ever be public. None of it will ever be in court. This is just for us to have the best chance at a resolution, so we don't need to go to court anymore. Each attorney briefly summarizes the case, similar to a very informal opening statement. Step 2, private caucuses. After the opening session, the mediator separates the parties into different rooms. Each side speaks privately with the mediator or the magistrate judge. You can speak freely about your concerns, weaknesses, and desired outcomes. The mediator does not reveal your private information to the other side unless you give permission. So our mediator, the retired judge, was really good. Unfortunately, we didn't reach an agreement at that time, but I could see how people could reach an agreement. He is being given information, your deepest, darkest secrets, right? And he's going to see if he can work something out. Now, of course, there is the negotiating back and forth. The mediator shuttles between rooms, sharing offers and counteroffers, pointing out risk of trial and potential damages, encouraging realistic expectations. Now, the mediator, in this case, the magistrate judge, is not biased one way or the other. So it is an unbiased individual trying to reach a resolution that is palpable. And again, both sides are not going to like the resolution. Both sides may hate the resolution. And often I find that when both sides hate a resolution, that's actually the best resolution that can be achieved, because that means you gave a little bit, I gave a little bit. Maybe we both felt we gave more than we should have, but at the end of the day, it resolved itself, right? In copyright cases, money damages, injunctive relief, licensing agreements, attorney fees. That's what's probably going to be discussed. Reaching a settlement. If a deal is reached, the terms are written down immediately and signed by both sides. A notice of settlement is filed with the court. The case is dismissed once the final paperwork is complete. If no settlement is reached, the case continues to trial. The judge will not be told what was said during ADR, only that the ADR took place. Like I said, even the judge has no idea what happens in these meetings. So confidentiality is absolute under Federal Rules of Evidence 408. Nothing said or offered during ADR. And also, like, you don't need to be worried about offers. Those offers will never get out. Right? So maybe you offer something really, really good, but then later in trial, in discovery, you find out something really bad, and then the defendant can't think, oh, well, I'll take that offer that you gave me that one time. No, because it does not exist. Like this, it is a vacuum. And once it's like a room, once you leave the room, everything that was said in the room is gone. Promises, crying, laughing, whatever, it's all gone once you leave the room. So, cost savings, ADR is non-binding unless you settle. So the mediator cannot force a decision. So let me tell you the difference, right, between a mediator and an arbitrator. So you cannot confuse these two. If your judge, individual, or decision making is an arbitrator, they can force the decision. A mediator cannot. So before you go into this mediation, you have to make sure: am I going to mediation or am I going to arbitration? Because if you go to arbitration, that decision will stick, and it's a very different game. It's much less friendly because, again, there's consequences to actions. Here, there's no consequences. You're just trying to throw everything on the table and figure out a solution that would save you money, right? The main thing is it saves a lot of money from depositions, expert witnesses, and trial preparation. So the federal courts in California usually require ADR to occur early, between 90 to 120 days after the first scheduling conference. So this is federal court, right? So the federal court, Central, Northern, Southern districts of California, is ADR mandatory? Almost always, yes. Local Rule 1615 requires ADR selection unless excused. Now, California State Court, ADR sometimes. In settlement conference, yes, before the trial. So if you refuse to go to ADR, the judge will order you to attend the settlement conference or view your refusal negatively and may even award attorney fees for not going, right? Not just your attorney fees, but the plaintiff. So you're the defendant, then the plaintiff will get some attorney fees. You're the defendant, then the plaintiff will get attorney. So you have to go. This isn't like a optional thing that you have fun with. No, you have to go. Anyway, let me know what you guys think in the comments below. Love to hear from you guys. Also, give this video a like, and we'll cover, there's one more interesting document we have yet to cover. We'll cover that document tomorrow then, if you guys like this video enough. Anyway, hopefully this explains it, because it's super important you guys understand it. From somebody who's just done one of these things, it's far more, like, the rules are completely different than when you go to trial. And the whole idea is, like, maybe we should all just settle and get along, right? So let me know what you guys think, or if you guys have any questions about the process. Again, in federal court, this is something that everyone has to do, essentially. Anyway, bye, guys.